Consideration, validity. Lolita was employed in a finance company because she could not account for the funds entrusted to her. She was charged with estafa and ordered arrested. In order to secure her release from jail, her parents executed a promissory note to pay the finance company the amount allegedly misappropriated by their daughter. The finance company then executed an affidavit of desistance, which led to the withdrawal of the information against Lolita and her release from jail. The parents failed to comply with their promissory note, and the finance company sued them for specific performance. Will the action prosper? The action will prosper. The promissory note executed by Lolita's parents is valid and binding. The consideration being the extinguishment of Lolita's civil liability and not the stifling of the criminal prosecution. Miguel's answer: the action will prosper. The promissory note is valid and can therefore give rise to a cause of action upon non-fulfillment. The parents failing to pay, the finance company can therefore sue them for the payment of the amount due. Conditional obligations. Pedro promised to give his grandson a car if the latter will pass the bar examinations. When his grandson passed the said examinations, Pedro refused to give the car on the ground that the condition was a purely potestative one. Is he correct or not? No, he is not correct. First of all, the condition is not purely potestative because it does not depend on the sole will of one of the parties. Secondly, even if it were, it would be valid because it depends on the sole will of the creditor, the donee, and not of the debtor, the donor. Miguel's answer: no, he is not correct. A potestative condition is a condition whose fulfillment is dependent on the sole will of one of the parties. The condition imposed by Pedro of his grandson passing the bar is not a potestative condition. It is a mixed condition as its fulfillment is dependent on chance and upon the will of the parties. Extinguishment, condonation. Arturo borrowed 500,000 from his father. After he had paid 300,000, his father died. When the administrator of his father's estate requested payment of the balance of 200,000, Arturo replied that the same had been condoned by his father, as evidenced by a notation on the back of his check payment for the 300,000, reading, "In full payment of the loan." Will this be a valid defense in an action for collection? It depends. If the notation "in full payment of the loan" was written by Arturo's father, there was an implied condonation of the balance that discharges the obligation. In such case, the notation is an act of the father from which condonation may be inferred. The condonation being implied need not comply with the formalities of a donation to be effective. The defense of full payment will therefore be valid. When, however, the notation was written by Arturo himself, it merely proves his intention in making that payment, but in no way does it bind his father. Yam vs. C.A., February 11, 1999. In such case, the notation was not the act of his father from which condonation may be inferred. There being no condonation at all, the defense of full payment will not be valid. Miguel's answer: it is a valid defense if the condonation was done by the father. If the notation at the back of the check was written by the father, then it may be deemed an implied condonation of the remaining balance of the loan. Extinguishment, extraordinary inflation, or deflation. On July 1st, 1998, Brian leased an office space in a building for a period of 5 years at the rental rate of $1,000 a month. The contract of lease contained the proviso that in case of inflation or devaluation of the Philippine peso, the monthly rental will automatically be increased or decreased depending on the devaluation or inflation of the peso to the dollar. Starting March 1, 2001, the lessor increased the rental to $2,000 a month on the ground of inflation proven by the fact that the exchange rate of the Philippine peso to the dollar had increased from 25 pesos equals $1 to 50 equals $1. Brian refused to pay the increased rate, and an action for unlawful detainer was filed against him. Will the action prosper? Why? The unlawful detainer action will not prosper. Extraordinary inflation or deflation is defined as the sharp decrease in the purchasing power of the peso. It does not necessarily refer to the exchange rate of the peso to the dollar. Whether or not there exists an extraordinary inflation or deflation is for the courts to decide. There being no showing that the purchasing power of the peso had been reduced tremendously, there could be no inflation that would justify the increase in the amount of rental to be paid. Hence, Brian could refuse to pay the increased rate. Miguel's answer: the action will not prosper. For the defense of inflation or deflation to be valid, there must be an official pronouncement or declaration. Extinguishment, assignment of rights. The sugarcane planters of Batangas entered into a long-term milling contract with the Central Azucarera de Don Pedro Incorporated. 10 years later, the Central assigned its right to the said milling contract to a Taiwanese group which would take over the operations of the sugar mill. The planters filed an action to annul the said assignment on the ground that the Taiwanese group was not registered with the Board of Investments. Will the action prosper or not? Explain briefly. The action will prosper not on the ground invoked, but on the ground that the farmers have not given their consent to the assignment. The milling contract imposes reciprocal obligations on the parties. The Sugar Central has the obligation to mill the sugar cane of the farmers, while the latter have the obligation to deliver their sugar cane to the Sugar Central. As to the obligation to mill the sugar cane, the Sugar Central is a debtor of the farmers. In assigning its rights under the contract, the Sugar Central will also transfer to the Taiwanese its obligation to mill the sugar cane of the farmers. This will amount to a novation of the contract by substituting the debtor with a third party under Article 1293 of the Civil Code. Such substitution cannot take effect without the consent of the creditor. The farmers, who are creditors as far as the obligation to mill their sugar cane is concerned, may annul such assignment for not having their consent thereto. Miguel's answer: the action will prosper. The assignment should be annulled. The assignment of the rights of Central Azucarera to the Taiwanese group amounts to a novation of the contract with the substitution of the debtor. For there will be a valid substitution, consent of the creditor must be obtained. In this case, the consent of the farmers was not obtained by the Central Azucarera before assigning the rights to the Taiwanese group. The assignment is therefore invalid. 4 foreign medical students rented the apartment of Thelma for a period of 1 year. After 1 semester, 3 of them returned to their home country, and the 4th transferred to a boarding house. Thelma discovered that they left unpaid telephone bills in the total amount of 80,000. The lease contract provided that the lessees shall pay for the telephone services in the leased premises. Thelma demanded that the 4th student pay the entire amount of the unpaid telephone bills, but the latter is willing to pay only 1/4 of it. Who is correct? The 4th student is correct. His liability is only joint, hence pro rata. There is solidary liability only when the obligation expressly so states, or when the law or nature of the obligation requires solidarity. Article 1207. The contract of lease in the problem does not in any way stipulate solidarity. Miguel's answer: the 4th student is correct. The obligation is a joint obligation. When the obligation concerns multiple debtors without stating the nature of the obligation of each, it is presumed that the obligation is joint. There is solidary obligation only when the parties intend that the obligation be solidary. Solidary obligations are never presumed and must be specifically stated in the agreement. Otherwise, the default rule is that it is joint obligation. Extinguishment compensation. Stockton is a stockholder of Core Corporation. He desires to sell his shares in Core Corporation. In view of a court suit that Core Corporation has filed against him for damages in the amount of $10 million, plus attorney's fees of $1 million as a result of statements published by Stockton, which are allegedly defamatory because it was calculated to injure and damage the corporation's reputation and goodwill. The article of incorporation of Core Corporation provide for a right of first refusal in favor of the corporation. Accordingly, Stockton gave written notice to the corporation of his offer to sell his shares of $10 million. The response of Core Corporation was an acceptance of the offer in the exercise of its right of first refusal, offering for the purpose payment in form of compensation or set off against the amount of damages it is claiming against him, exclusive of the claim for attorney's fees. Stockton rejected the offer of the corporation, arguing that compensation between the value of the shares and the amount of damages demanded by the corporation cannot legally take effect. Is Stockton correct? Give reason for your answer. Suggested answer. Stockton is correct. There is no right of compensation between his price of $10 million and Core Corporation's unliquidated claim for damages. In order that compensation may be proper, the two debts must be liquidated and demandable. The case for the $10 million damages being still pending in court, the corporation has as yet no claim, which is due and demandable against Stockton. Miguel's answer. Stockton is correct. In order for there to be a valid compensation, one of the requisites that Article 1279 of the Civil Code provides is that the debts are liquidated and demandable. In this case, since the claim for damages is still pending in court, the amount has not yet been liquidated, yet, therefore, one of the requisites for a valid compensation is lacking. Nature of contracts. Relativity of contracts. Printado is engaged in the printing business. Suplico supplies printing paper to Printado pursuant to an order agreement, under which Suplico binds himself to deliver the same volume of paper every month for a period of 18 months, with Printado in turn agreeing to pay within 60 days after each delivery. Suplico has been faithfully delivering under the order agreement for 10 months, but thereafter stopped doing so, because Printado has not made any payment at all. Printado has also a standing contract with publisher Publico for the printing of 10,000 volumes of school textbooks. Suplico was aware of said printing contract. After printing 1,000 volumes, Printado also fails to perform under its printing contract with Publico. Suplico sues Printado for the value of the unpaid deliveries under their order agreement. At the same time, Publico sues Printado for damages for breach of contract with respect to their own printing agreement. In this suit filed by Suplico, Printado counters that A. Suplico cannot demand payment for deliveries made under the order agreement until Suplico has completed performance under said contract. B. Suplico should pay damages for breach of contract. And C. With Publico should be liable for Printado's breach of his contract with Publico because the order agreement between Suplico and Printado was for the benefit of Publico. Are the contentions of Printado tenable? Explain your answer as to each contention. I'm so confused with the names. No, the contentions of Printado are untenable. Printado having failed to pay for the printing paper covered by the delivery invoices on time, Suplico has the right to cease making further delivery, and the latter did not violate the order agreement. Integrated Packing Corporation for this Court of Appeals, June 8, 2000. Suplico cannot be held liable for damages for breach of contract, as it was not he who violated the order agreement but Printado. Suplico cannot be held liable for Printado's breach of contract with Publico. He is not a party to the agreement entered into by and between Printado and Publico. Theirs is not a stipulation pour atruit. Such contracts could not affect third persons like supplico because of the basic civil law principle of relativity of contracts, which provides that contracts can only bind the parties who entered into it and cannot favor or prejudice a third person, even if he is aware of such contract and has acted with knowledge thereof. Miguel's answer: the contentions of Printado are unmeritorious. Printado failed to comply with his obligation to pay Supplico for the printing papers that Supplico has delivered. Supplico, therefore, had the right to stop making further delivery until Printado complies with their obligation. Supplico cannot be held liable for damages, as it was Printado who breached the contract because of their non-payment despite the prior deliveries made by Supplico of the printing papers. Supplico cannot be held liable for the failure of Printado to comply with. Printado's obligation to Publico as Supplico is not part of the contract between the prior two. Conditional obligations. Are the following obligations valid? Why? And if they are valid, when is the obligation demandable in each case? A. If the debtor promises to pay as soon as he has the means to pay. B. If the debtor promises to pay when he likes. C. If the debtor promises to pay when he becomes a lawyer. If the debtor promises to pay if his son, who is sick with cancer, does not die within 1 year. Letter D. Suggested answer A. The obligation is valid. It is an obligation subject to an indefinite period because the debtor binds himself to pay when his means permit him to do so. Article 1180. When the creditor knows that the debtor already has the means to pay, he must file an action in court to fix the period, and when the definite period as set by the court arrives, the obligation to pay becomes demandable. Article 1197. Letter B. The obligation to pay when he likes is a suspensive condition, the fulfillment of which is subject to the sole will of the debtor, and therefore the conditional obligation is void. Article 1182. Letter C. The obligation is valid. It is subject to a suspensive condition, the future and uncertain event of his becoming a lawyer. The performance of this obligation does not depend solely on the will of the debtor, but also on other factors outside the debtor's control. Letter D. The obligation is valid. The death of the son of cancer within 1 year is made a negative suspensive condition to his making the payment. The obligation is demandable if the son does not die within 1 year. Article 1185. Miguel's answer, letter A, valid. It is an obligation subject to an indefinite period and is demandable upon the fixing of the period by the parties or through the courts. Letter B, void. The obligation is an obligation subject to a potestative condition which, according to the Civil Code, are considered void. C, valid. The obligation is an obligation subject to a suspensive condition and is demandable upon the occurrence of the condition, or, as in this case, upon his becoming a lawyer. Letter D, valid. The obligation is subject to a suspensive condition. It is demandable upon the end of 1 year, if his son has not died by then. Liability, solidarial obligation, mutual guarantee. A, B, C, D, and E made themselves solidarity indebted to X for the amount of 50,000. When X demanded payment from A, the latter refused to pay on the following grounds. A. B is only 16 years old. Letter B. C has already been condoned by X. Letter C. D is insolvent. Letter D. E was given by X an extension of 6 months without the consent of the other 4 co-debtors. State the effect of each of the above defenses put up by A on his obligation to pay X, if such defenses are found to be true. Letter A. A may avail the minority of B as a defense, but only for B's share, 10,000. A solidary debtor may avail himself of any defense which personally belongs to a solidary co-debtor, but only as to the share of that co-debtor. B. A may avail of the condonation of X of C's share of 10,000. A solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation, and of those which are personal to him or pertain to his own share. With respect to those which personally belong to others, he may avail himself thereof only as regards that part of the debt for which the latter are responsible. Letter C. A may not interpose the defense of insolvency of D as a defense. Applying the principle of mutual guarantee among solidary debtors, A guaranteed the payment of this share and all of the other co-debtors. Hence, A cannot avail of the defense of this insolvency. D. The extension of 6 months given by X to E may be availed of by A as a partial defense, but only for the share of E. There is no novation of the obligation, but only an act of liberality granted to E alone. Miguel's answer: the share of that co-debtor would be deducted from the total amount due. The minority of one of the solidary co-debtors is a valid defense and would benefit his co-debtors. Letter B. The part of C will be deducted from the total amount that is due and demandable from the remaining co-debtors. Letter C. The co-debtors would have to shoulder the share of an insolvent co-debtor in proportion to their share in the debt. Letter D. The extension would benefit A only as to the share of E. The amount that is demandable would therefore be reduced to an amount subtracting the share of E until his share becomes due and demandable. Inexistent contracts versus unknowable contracts. Distinguish briefly but clearly between inexistent contracts and unknowable contracts. 2004. Inexistent contracts are considered as not having been entered into and therefore void ab initio. They do not create any obligation and cannot be ratified or validated, as there is no agreement to ratify or validate. On the other hand, unknowable or voidable contracts are valid until invalidated by the court, but may be ratified. In inexistent contracts, one or more requisites of a valid contract are absent. In unknowable contracts, all the elements of a contract are present except that the consent of one of the contracting parties was vitiated or one of them has no capacity to give consent. Miguel's answer: inexistent contracts are contracts that have no force and effect from the beginning and which cannot be ratified by lapse of time. An unknowable contract or a voidable contract, on the other hand, are contracts which are valid until annulled. Voidable contracts are subject to ratification. Contracts of option elements. Marvin offered to construct the house of Carlos for a very reasonable price of $900,000, giving the latter 10 days within which to accept or reject the offer. On the 5th day, before Carlos would make up his mind, Marvin withdrew his offer. A. What is the effect of the withdrawal of Marvin's offer? Suggested answer: the withdrawal of Marvin's offer will cause the offer to cease in law. Hence, even if subsequently accepted, there could be no concurrence of the offer and the acceptance. In the absence of concurrence of offer and acceptance, there can be no consent. Laudico versus Arias Rodriguez. Without consent, there is no perfected contract for the construction of the house of Carlos. Salonga versus Farales. Article 1318 of the Civil Code provides that there can be no contract unless the following requisites concur. Consent of the parties. Number 2. Object contained, which is the subject matter of the contract. And 3. Cause of the obligation. Marvin will not be liable to pay Carlos any damages for withdrawing the offer because the lapse of the period granted. In this case, no consideration was given by Carlos for the option given. Thus, there is no perfected contract of option for lack of cause of obligation. Marvin could not held to have breached the contract. Thus, he cannot be held liable for damages. Miguel's answer: the withdrawal of the offer means that there can be no contract. A contract would only be born upon the meeting of the minds of the parties and the acceptance of the offer of one by the other. There being no offer, acceptance cannot be effected, thereby eliminating the possibility of having a contract. B. Will your answer be the same if Carlos paid Marvin $10,000 as consideration for that option? Answer: my answer will be the same as to the perfection of the contract for the construction of the house of Carlos. No perfected contract arises because of lack of consent. With the withdrawal of the offer, there could be no concurrence of offer and acceptance. Miguel's answer: yes, my answer will be the same. Since there is no perfected contract, no obligation arises. Letter C. Supposing that Carlos accepted the offer before Marvin could communicate his withdrawal thereof, discuss the legal consequences. Suggested answer: a contract to construct the house of Carlos is perfected. Contracts are perfected by mere consent, manifested by the meeting of the offer and the acceptance upon the thing and the costs which are to constitute the contract. Gomez versus Court of Appeals. Under Article 1315 of the Civil Code, Carlos and Marvin are bound to fulfill what has been expressly stipulated and all consequences thereof. Under Article 1167, if Marvin would refuse to construct the house, Carlos is entitled to have the construction be done by a third person at the expense of Marvin. Marvin, in that case, will be liable for damages under Article 1170. Miguel's answer: if the offer was accepted before it was withdrawn, there is a valid contract that can be the source of obligations arising from their agreements. 2007. Obligations. What are the obligations without an agreement? Give examples of situations giving rise to this type of obligation. Obligations without an agreement are obligations that do not arise from contract, such as those arising from 1. Delicts, 2. Quasi-delicts, 3. Solutio indebiti, 4. Negotiorum gestio, and 5. All other obligations arising from law. Compensation. 2008. Eduardo was granted a loan by XYZ Bank for the purpose of improving a building which XYZ leased from him. Eduardo executed the promissory note in favor of the bank, with his friend Ricardo as co-signatory. In the PN promissory note, they both acknowledge that they are individually and collectively liable and waive the need for prior demand. To secure the promissory note, Ricardo executed a real estate mortgage on his own property. When Eduardo defaulted on the promissory note, XYZ stopped payment of rentals on the building on the ground that legal compensation had set in, since there was still a balance due on the promissory note after applying the rentals. XYZ foreclosed the real estate mortgage over Ricardo's property. Ricardo opposed the foreclosure on the ground that he is only a co-signatory, that no demand was made upon him for payment, and assuming he is liable, his liability should not go beyond half the balance of the loan. Further, Ricardo said that when the bank invoked compensation between the rentals and the amount of the loan, it amounted to a new contract or novation and had the effect of extinguishing the security, since he did not give his consent as owner of the property under the real estate mortgage thereto. A. Can XYZ Bank validly assert legal compensation? B. Can Ricardo's property be foreclosed to pay the full balance of the loan? C. Does Ricardo have basis under the Civil Code for claiming that the original contract was novated? Suggested answer: A. XYZ may validly assert the partial compensation of both debts, but it should be facultative compensation because not all of the 5 requisites of legal compensation are present. The payment of the rentals by XYZ Bank is not yet due, but the principal obligation of loan, where both Eduardo and Ricardo are bound solidarily and therefore any of them is principally bound to pay the entire loan, is due and demandable without need of demand. XYZ Bank may declare its obligation to pay rentals as already due and demand payment from any of the 2 debtors. Letter B. No, because there was no prior demand on Ricardo, depriving him of the right to reasonably block the foreclosure by payment. The waiver of prior demand on the promissory note is against public policy and violates the right to due process. Without demand, there is no default and the foreclosure is null and void. Since the mortgage, insofar as Ricardo is concerned, is not violated, a requirement under Article 3135 for a valid foreclosure of real estate mortgage is absent. In the case of DBP versus Liquanan, it was held that the issue of whether demand was made before the foreclosure was effected is essential. If demand was made and duly received by the respondents, and the latter still did not pay, then they were already in default and foreclosure was proper. However, if demand was not made, then the loan had not yet become due and demandable. This meant that respondents had not defaulted in their payment and the foreclosure was premature. Letter C. None of the three kinds of novation is applicable. There is no objective novation, whether expressed or implied, because there is no change in the object or principal conditions of the obligation. There is no substitution of debtors either. Compensation is considered as abbreviated or simplified payment, and since Ricardo bound himself solidarily with Eduardo, any facultative compensation which occurs does not result in partial legal subrogation. Neither Eduardo nor Ricardo is a third person interested in the obligation under Article 1302 of the Civil Code. Miguel's answer. A. XYZ may assert compensation. The requisites of a valid application of compensation are present in this case. XYZ and Eduardo are creditors of one another. Eduardo as to the promissory note that is due and XYZ as to the rentals which are also due. Both debts are demandable and both consist in debts of a sum of money that is liquidated and demandable. All of the requisites for compensation are present, and this XYZ may validly apply compensation in the fulfillment of the death of Eduardo to them. Letter B. Ricardo's property may be foreclosed upon proper showing that demand was made upon him and he failed to pay, without which foreclosure cannot be effected. Letter C. None. There is no novation in this case, as there was no change in object, condition, or debtor. Felipe borrowed $100 from Gustavo in 1998 when the Philippines U.S. exchange was 56 is to $1. On March 1, 2008, Felipe tendered to Gustavo a cashier's check in the amount of $4,135 in payment of his US dollars 100 debt, based on the Philippine exchange rate at that time. Gustavo accepted the check but forgot to deposit it until September 12, 2008. His bank refused to accept the check because it had become stale. Gustavo now wants Felipe to pay him cash the amount of $5,600, claiming that the previous payment was not in legal tender and that there has been extraordinary deflation since 1998, and therefore Felipe should pay him the value of the debt at the time it was incurred. Felipe refused to pay him again, claiming that Gustavo is stopped from raising the issue of legal tender, having accepted the check in March, and that it was Gustavo's negligence in not depositing the check immediately that caused the check to become stale. A. Can Gustavo now raise the issue that the cashier's check is not legal tender? B. Can Felipe validly refuse to pay Gustavo again? C. Can Felipe compel Gustavo to receive the $100 instead? Letter A. No, because Gustavo is guilty of estoppel by laches. He led Felipe to believe that he could pay by cashier's check, and Felipe relied that such cashier's check would be in cash, thus extinguishing his obligation. Because of Gustavo's inaction of more than 6 months, the check became stale, and Felipe will be prejudiced if he will be required to pay $100 at the exchange rate of 56 to $1. The exchange should be the rate at the time of payment. B. Yes, if the payment is valid, since the bank considered the cashier's check as being stale for not being encashed on time, then the cashier's check may be issued again. At any rate, non-payment of the amount to Gustavo would constitute unjust enrichment. C. Yes, Felipe can compel Gustavo to pay $100. Under RA 529, as amended by RA 4100, payment can only be in Philippine currency, as it would be against public policy, null and void, and of no effect. However, under RA 8183, payment may be made in the currency agreed upon, and the rate of exchange to be followed is at the time of payment. Miguel's answer. Letter A. Gustavo cannot use the defense that the check was not legal tender because he has already accepted it. Gustavo's acceptance of the check was tantamount to a valid payment, thereby extinguishing the obligation. While a check is not legal tender, Gustavo is bound by estoppel from questioning it as he accepted it, despite knowing such. Letter B. Yes, Felipe can refuse to pay Gustavo again. The acceptance of the payment of Felipe by Gustavo effectively extinguished his obligation to him. Gustavo was negligent in not encashing the check immediately, and Felipe should not be faulted for that. Letter C. Yes, if it was the currency agreed upon by the parties, otherwise Felipe should pay in Philippine peso, which is the legal tender in the Philippines. AB Corporation entered into a contract with XY Corporation whereby the former agreed to construct the research and laboratory facilities of the latter. Under the terms of the contract, AB Corporation agreed to complete the facility in 18 months at the total contract price of $10 million. XY Corporation paid 50% of the total contract price, the balance to be paid upon completion of the work. The work started immediately, but AB Corporation later experienced work slippage because of labor unrest in its company. AB Corporation's employees claim that they are not being paid on time, hence the work slowed down. As of the 17th month, work was only 45% completed. AB Corporation asked for extension of time, claiming that its labor problem is caused of or by fortuitous event, but this was denied by XY Corporation. When it became certain that the construction could not be finished on time, XY Corporation sent written notice canceling the contract and requiring AB Corporation to immediately vacate the premises. A. Can the labor unrest be considered a fortuitous event? B. Can XY Corporation unilaterally and immediately cancel the contract? Letter C. Must AB Corporation return the 50% down payment? Suggested answer. Letter A. Labor unrest is not a fortuitous event that will excuse AB Corporation from complying with its obligation of constructing the research and laboratory facilities of XY Corp. The labor unrest, which may even be attributed in large part of AB Corporation, itself is not the direct cause of non-compliance of AB Corporation. It is independent of its obligation. It is similar to the failure of a DBP borrower to pay her loan just because her plantation suffered losses due to the kadang-kadang disease. It does not excuse compliance with the obligation. Letter B. Yes, XY Corporation may unilaterally cancel the obligation, but this is subject to the risk that the cancellation of the reciprocal obligation being challenged in court, and if AB Corporation succeeds, then XY Corporation will be declared in default and be liable for damages. Letter C. No, under the principle of quantum merit, AC Corporation has the right to retain payment corresponding to its percentage of accomplishment, less the amount of damages suffered by XY Corporation because of the delay or default. 2012. Elements of an obligation. The following are the elements of an obligation exempt. Letter A. Juridical legal tie. B. Active subject. C. Passive subject. D. Consideration. Suggested answer is D. Consideration. Upon the proposal of a third person, a new debtor substituted the original debtor without the latter's consent. The creditor accepted the substitution. Later, however, the new debtor became insolvent and defaulted in his obligation. What is the effect of the new debtor's default upon the original debtor? Letter A. The original debtor is freed of liability since novation took place, and this relieved him of his obligation. B. The original debtor shall pay or perform the obligation with recourse to the new debtor. C. The original debtor remains liable since he gave no consent to the substitution. D. The original debtor shall pay or perform 50% of the obligation to avoid unjust enrichment of his part. Suggested answer, letter A. The original debtor is freed of liability since novation took place, and this relieved him of his obligation. When bilateral contracts are vitiated with vices of consent, they are rendered rescisable, void, unenforceable, voidable. Suggested answer is voidable. An agent authorized by special power of attorney to sell a land belonging to the principal succeeded in selling the same to a buyer according to the instructions given the agent. The agent executed the deed of absolute sale on behalf of his principal 2 days after the principal died, an event that neither the agent nor the buyer knew at the time of the sale. What is the standing of the sale? Suggested answer, valid. Contracts take effect only between the parties or their assigns and heirs, except where the rights and obligations arising from the contract are not transmissible by their nature, by stipulation, or by provision of law. In the latter case, the assigns or the heirs are not bound by the contracts. This is known as the principle of relativity of contracts. A buyer ordered 5,000 apples from the seller at 20 pesos per apple. The seller delivered 6,000 apples. What are the rights and obligations of the buyer? Suggested answer, he can accept all 6,000 apples and pay the seller at 20 pesos per apple. Lino entered into a contract to sell with Ramon, undertaking to convey to the latter one of the 5 lots he owns, without specifying which lot it was, for the price of 1 million. Later, the parties could not agree which of the 5 lots he owned Lino undertook to sell to Ramon. What is the standing of the contract? Rescisible, void, voidable, unenforceable. Suggested answer is void. Rodolphe borrowed 1 million from Rodrigo and Fernando, who acted as solidary creditors. When the loan matured, Rodrigo wrote a letter to Rodolphe demanding payment of the loan directly to him. Before Rodolphe could comply, Fernando went to see him personally to collect, and he paid him. Did Rodolphe make a valid payment? No, since Rodrigo, the other solidary creditor, already made a prior demand for payment from Rodolphe. Alan bought Billy's property through Carlos, an agent empowered with a special power of attorney to sell the same. When Alan was ready to pay as scheduled, Billy called, directing Alan to pay directly to him. On learning of this, Carlos, Billy's agent, told Alan to pay through him as his SPO provided and to protect his commission. Faced with 2 claimants, Alan consigned the payment in court. Billy protested, contending that the consignation is ineffective since no tender of payment was made to him. Is he correct? Suggested answer, no, since consignation without tender of payment is allowed in the face of the conflicting claims on the plaintiff. X sold Y 100 sacks of rice that Y was to pick up from X rice mill on the particular date. Y did not, however, appear on the agreed date to take delivery of the rice. After 1 week, X automatically rescinded the sale without notarial notice to Y. Is the rescission valid? Yes, automatic rescission is allowed since having the character of movables and consumables, rice can easily deteriorate. Roy and Carlos both undertook a contract to deliver to Sam in Manila a boat docked in Subic. Before they could deliver it, however, the boat sank in a storm. The contract provides that fortuitous events shall not exempt Roy and Carlos from their obligation. Owing to the loss of the motorboat, such obligation is deemed converted into one of indemnity for damages. Is the liability of Roy and Carlos joint or solidary? Joint, since the conversion of their liability to one of indemnity for damages made it joint. Natural obligation under the new Civil Code of the Philippines is one which cannot be judicially enforced but authorizes the obligee to return the obligor's payment or performance. Anne owed Bessie 1 million due on October 1st, 2011, but failed to pay her on due date. Bessie sent a demand letter to Anne, giving her 5 days from receipt within which to pay. 2 days later after receipt of the letter, Anne personally offered to pay Bessie in manager's check, but the latter refused to accept the same. The 5 days lapsed. May Anne's obligation be considered extinguished? No, since tender of payment even in cash, if refused, will not discharge the obligation without proper consignation in court. The presence of a vice of consent vitiates the consent of a party in a contract, and this renders the contract voidable. Obligation. It is a conduct that may be consist of giving, doing, or not doing something. Prestation. Delay. A debtor is liable for damages in case of delay if he is guilty of any of the following except default, mistake, negligence, breach through contravention of the tenor thereof. Suggested answer, mistake. Delay. This term refers to delay on the part of both the debtor and creditor in reciprocal obligation. Mora assipendi, mora solvendi. Comprehension more, solution in debiti. Suggested answer, compensation more. Delay. The following are requisites of mora solvendi except obligation pertains to the debtor and is determinate, due, demandable, and liquidated. Obligation was performed on its maturity date. There is a judicial or extrajudicial demand by the creditor. Failure of the debtor to comply with such demand. Suggested answer, obligation was performed on its maturity date. Fortuitous event. A debtor may still be held liable for loss or damages even if it was caused by a fortuitous event in any of the following instances. Except the debtor is guilty of dolo, malice, or bad faith, has promised the same thing to two or more persons who do not have the same interest. B. The debtor contributed to the loss. C. The thing to be delivered is generic. D. The creditor is guilty of fraud, negligence, or delay, or if he contravened the tenor of the obligation. Suggested answer, C. The thing to be delivered is generic. Solidary obligation. Buko, Fermin, and Todi bound themselves solidarily liable to pay Ayi the amount of 5,000. Suppose Buku paid the obligation, what is his right as against his co-debtors? Suggested answer, Buku can ask for reimbursement from Fermin and Todi. Solidary obligation. Buku, Fermin, and Todi bound themselves solidarily to pay Ayi the sum of 10,000 pesos. When the obligation became due and demandable, Ayi sued Buku for the payment of the 10,000. Buku moved to dismiss on the ground that there was failure to implead Fermin and Todi, who are indispensable parties. Will the motion to dismiss prosper? Why? Suggested answer, no, because the creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. Solidary obligation. Buku, Fermin, and Todi are solidary debtors of Ayi. 12 years after the obligation became due and demandable, Buku paid Ayi and later on asked for reimbursement of Fermin's and Todi's shares. Is Buku correct? Why? Suggested answer, no, because the obligation has already prescribed. Buku, Fermin, and Todi are solidary debtors under a loan obligation of 300,000, which has fallen due. The creditor has, however, condoned Fermin's entire share in the debt. Since Todi has become insolvent, the creditor make a demand on Buku to pay the debt. How much, if any, may Buku be compelled to pay? Suggested answer, 200,000. Dina bought a car from Jai and delivered a check in payment of the same. Has Dina paid the obligation? Why? Suggested answer, no. Not yet. The delivery of the promissory notes payable to order, or bills of exchange, or other mercantile documents shall produce the effect of payment only when they have been cashed, or when through the fault of the creditor they have been impaired. Compensation. The following are the requisites of legal compensation exempt. That each of the obligors is bound principally and that he be the same time a principal creditor of the other. B. That both debts consist in sum of money, or if the things due are consumable, they be the same kind, and also of the same quality if the latter has been stated. Letter C. That the two debts are not yet due. And D. That they be liquidated and demandable. Suggested answer, letter C. That the two debts are not yet due. Contracts. Which of the following statements are correct? All contracts are perfected by mere consent. All contracts are perfected by delivery of the object. All contracts are required to be in writing. All contracts are required to have a valid consideration. Suggested answers, letter D. All contracts are required to have a valid consideration. Contracts. It is a principle that holds that parties are bound not only by what has been expressly provided for in the contract, but also to the natural consequences that flow out of such agreement. Suggested answer, obligatory force of contracts. It is a principle which holds that contracts must be binding to both parties, and its validity and effectivity can never be left to the will of the one of the parties. Mutuality of contracts. It refers to the rule that a contract is binding not only between the parties but extends to the heirs, successors in interest, and assignees of the parties, provided that the contract involve transmissible rights by their nature or by stipulation of law. Suggested answer, letter D, relativity of contracts. It is a rule which holds that the freedom of parties to contract includes the freedom to stipulate, provided the stipulations are not contrary to law, morals, good customs, public order, or public policy. Suggested answer, autonomy of contracts. The following are the ways by which innominate contracts are regulated except by the stipulation of the parties, B. By the general principles of quasi-contracts and delicts, C. By the rules governing the most analogous nominate contracts, D. By the customs of the place. Suggested answer, B. By the general principles of quasi-contracts and delicts. The following are solemn contracts, contracts which must appear in writing except donation of free property or movables if the value exceeds 5,000, a stipulation to pay interest in loans, sale of land through an agent authority must be in writing, construction contracts of a building. Answer D. Construction contract of a building. The following are rescissible contracts except A. Entered into by guardian whenever ward suffers damage more than 1/4 of value of property, agreed upon in representation of absentees if absentee suffers lesion by more than 1/4 value of property. Letter C. Contracts where fraud is committed on creditor action Pauliana. And letter D. Contracts entered into by minors. Answer is letter D. Contracts entered into by minors. Contracts. The following are requisites before a contract entered into in fraud of creditors may be rescinded except there must be a credit existing prior to the celebration of the contract. B. There must be fraud, or at least the intent to commit fraud, to the prejudice of the creditor seeking rescission. C. The creditor cannot in any legal manner collect his credit subsidiary character of rescission. D. The object of the contract must be legally in the possession of a third person in good faith. Suggested answer is letter D. The object of the contract must be legally in the possession of a third person in good faith. The following are the characteristics of a voidable contract except A. Effective until set aside. B. May be assailed or attacked only in an action for that purpose. C. Can be confirmed or ratified. D. Can be assailed only by either party. Answer D. Can be assailed only by either party. The following are void contracts except Pactum commissorium, Pactum de non alienando, see Pactum leonine or leonine, Pacto de retro. Suggested answer, Pacto de retro. Right to the fruits of the thing due. The creditor has the right to the fruits of the thing due from the time the obligation to deliver the thing arises. If one of the parties to the contract is without juridical capacity, the contract is void. When both parties to the contract are minors, the contract is unenforceable. When the consent of one of the parties was vitiated, the contract is voidable. An obligation which is based on equity and natural law is known as natural. Consent was given by one in representation of another, but without authority, the contract is unenforceable. Michael Fermin, without the authority of Pascual Lacasse, owner of a car, sold the same car in the name of Mr. Lacasse to Attorney Bucco. The contract between Attorney Bucco and Mr. Lacasse is unenforceable because Michael Fermin had no authority, but he sold the car in the name of Mr. Lacasse, the owner. Which of the following contracts is void? An oral sale of a parcel of land. B. A sale of land by an agent in a public instrument where his authority from the principal is oral. Letter C. A donation of a wrist watch worth $4,500. D. A relatively simulated contract. Suggested answer B. A sale of land by an agent in a public instrument where his authority from the principal is oral. Aligada orally offered to sell his 2 hectares rice land to Balane for $10 million. The offer was orally accepted. By agreement, the land was to be delivered through execution of an authorized deed of sale, and the price was to be paid exactly 1 month from their oral agreement. Which statement is most accurate? A. If Aligada refuses to deliver the land on the agreed date despite payment by Balane, the latter may not successfully sue Aligada because the contract is oral. B. If Aligada refused to deliver the land, Balane may successfully sue for fulfillment of the obligation, even if he has not tendered payment of the purchase price. Letter C. The contract between the parties is rescissible. D. The contract between the parties is subject to ratification by the parties. Suggested answer: the contract between the parties is subject to ratification by the parties. Which of the following statement is wrong? A. Creditors are protected in cases of contracts intended to defraud them. B. Contracts take effect only between the parties, their assigns, and heirs, except in case where the rights and obligations arising from the contract are not transmissible by their nature or by stipulation or by provision of law. C. If a contract should contain some stipulation in favor of third person, he may demand its fulfillment, provided he communicated his acceptance to the obligor before its revocation. Letter D. In contracts creating real rights, third persons who come into possession of the object of the contract are not bound thereby. Suggested answer D. In contracts creating real rights, third persons who come into possession of the object of the contracts are not bound thereby. Form of contracts. Leto obtained a loan of $1 million from Ferdi, payable within 1 year. To secure payment, Leto executed a chattel mortgage on a Toyota Avanza and a real estate mortgage on a 200 square meter piece of property. A. Would it be legally significant from the point of view of validity and enforceability if the loan and the mortgages were in public or private instruments? B. Leto's failure to pay led to the extrajudicial foreclosure. Leto tendered a manager's check to Ferdi to redeem the property. Ferdi refused to accept payment on the ground that he wanted payment in cash. The check does not qualify as legal tender and does not include the interest payment. Is Ferdi's refusal justified? Suggested answer A. From the point of view of validity and enforceability, there would be legal significance if the mortgage was in a public or private instrument. As for the loan, there is no legal significance except if interest were charged on the loan, in which case the charging of interest must be in writing. A contract of loan is a real contract and is perfected upon the delivery of the object of the obligation. Article 1934. Thus, a contract of loan is valid and enforceable even if it is neither in a private nor in a public document. As a rule, contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. With regard to its enforceability, a contract of loan is not among those enumerated under Article 1403 of the Civil Code, which are covered by the Statute of Frauds. It is important to note that under Article 1358 of the Civil Code, all other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one. However, the requirement is not for the validity of the contract, but only for its greater efficacy. With regard to the chattel mortgage, Article 1508, the Chattel Mortgage Law, requires an affidavit of good faith, stating that the chattel mortgage is supposed to stand as security for the loan. Thus, for validity of the chattel mortgage, it must be in a public document and recorded in the Chattel Mortgage Register in the Registry of Deeds. A real estate mortgage under the provisions of Article 2125 of the Civil Code requires that in order that the mortgage may be validly constituted, the document in which it appears must be recorded. If the instrument is not recorded, the mortgage is nevertheless valid and binding between the parties. Hence, for validity of both chattel and real estate mortgages, they must appear in a public instrument. But for purposes of enforceability, it is submitted that the form of the contract, whether in a public or private document, would be immaterial. Also, under Article 1358, acts and contracts which have for their object the creation or transmission of real rights over immovable property must be in a public document for greater efficacy, and a real estate mortgage is a real right over immovable property. Letter B. Further's refusal is justified. A check, whether a manager's check or ordinary check, is not legal tender, and an offer for a check in payment of a debt is not a valid tender of payment and may be refused receipt by the obligee or creditors. Mere delivery of checks does not discharge the obligation under a judgment. A check shall produce the effect of payment only when they have been cashed or when through the fault of the creditor they have been impaired. Article 1249. However, it is not necessary that the right of redemption be exercised by delivery of legal tender. A check may be used for the exercise of right of redemption, the same being a right and not an obligation. The tender of a check is sufficient to compel redemption, but is not in itself a payment that relieves the redeemer from his liability to pay the redemption price. Redemption within the period allowed by law is not a matter of intent, but a question of payment or valid tender of full redemption price within the said period. Whether the redemption is being made under Article 3135 or under the general banking law, the mortgagor or his assignee is required to tender payment to make said redemption valid. Moreover, Further's refusal was justified on the ground that the amount tendered does not include interest. In order to effect the redemption of the foreclosed property, the payment to the purchaser must include the following sums: A. The bid price. B. The interest on the bid price, computed at 1% per month. And C. The assessments or taxes, if any, paid by the purchaser with the same rate of interest. Miguel's answer: A. There would only be legal significance if the mortgage was in a public or private instrument. It does not matter for the loan. A contract of loan is valid regardless if it is in a private or public document. For the mortgage, on the other hand, its validity would be dependent upon its being in a public document. B. Refusal of Freddie is justified. A check is not considered a legal tender. The creditor may validly refuse to accept the debtor's offer of payment if it's payment through a check. Solidary obligation. A, B, C, D are the solidary debtors of X for 40,000 pesos. X released D from the payment of his share of 10,000. When the obligation became due and demandable, C turned out to be insolvent. Should the share of insolvent debtor C be divided only between the two remaining debtors, A and B? Suggested answer: when one of the solidarity debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors, in proportion to the debt of each. Additionally, D was released only from his share of 10,000, not from the solidarity tie that binds him to A, B, and C. Delay. Gary is a tobacco trader and also a lending investor. He sold tobacco leaves to Homer for delivery within a month, although the period for delivery was not guaranteed. Despite Gary's effort to deliver on time, transportation problems and government red tape hindered his efforts, and he could only deliver after 30 days. Homer refused to accept the late delivery and to pay on the ground that the agreed term had not been complied with. As lending investor, Gary granted a $1 million loan to Isaac to be paid within 2 years from execution of the contract. For the loan, Isaac promised to deliver to Gary his Toyota Innova within 7 days, but Isaac failed to do so. Gary was thus compelled to demand payment for the loan before the end of the agreed 2-year term. Was Homer justified in refusing to accept the tobacco leaves? Answer: B. It is clear under the facts that the period of delivery of tobacco leaves was not guaranteed. Gary anticipated other factors which may prevent him from making the delivery within a month. True enough, transportation problems and government red tape did. Such slight delay was thus excusable. Obligations arising from contract have the force of law between the contracting parties and should be complied with in good faith. Can Gary compel Isaac to pay his loan even before the end of the 2-year period? Non-compliance with the promise, guarantee, or security renders the obligation immediately demandable. Isaac lost his right to make use of the period. Under Article 1198 of the Civil Code, the debtor shall lose every right to make use of the period when he does not furnish to the creditor the guarantees and securities which he has promised.